أشهد أن لا
أشهد أن لا
إله
إله
إلا الله
إلا الله
وأشهد
وأشهد
أن
أن
محمدا رسول الله.
محمدا رسول الله. Assalamualaikum Miss Sarah. My name is Aiman.
Waalaikumsalam. Oh, Mr. Aiman, you're the one who made a call yesterday, right? Have a seat.
We're here to discuss about our marriage status since I've converted to Islam.
And how about my children, since she is still a minor? So you come here to discuss about the effect of conversion to your marriage status?
Here we can give a few view about your issue with some explanation too, so you will understand more about this issue.
Law can be defined as a rule. It is used to govern how society lives. Law in Malaysia is passed and made by a legislative body called Parliament. They made so many laws, including for non-Muslims family matters. The law for non-Muslims in Malaysia is governed under the Law Reform Marriage and Divorce Act 1976. This act contains several rules and regulations on family matters for non-Muslims. One of the matters in Part 6 of LRA, which is dissolution of marriage or divorce. Generally, cases regarding the issue of divorce under the jurisdiction of Sharia law. However, if we look at the Administration of Islamic Law Federal Territories Act 1993, it has jurisdiction over Muslims only, so it is lies on High Court. High Court can hear and approve the application or petition of divorce for non-Muslims. Based on Section 48, Subsection 1, Law Reform Act 1976, the court can make any decree of divorce when the marriage is registered under this act based on paragraph A. In paragraph B, the marriage is monogamous, and in paragraph C, the party's domicile when the petition is presented is in Malaysia. Based on Section 15, there are no petition of divorce before the expiration of 2 years from the date of marriage. It means that the spouse cannot apply for petition of divorce between the first 2 years of their marriage. However, there are exceptions. They can apply for judicial separation and it can be brought from the first 2 years of their marriage. Also, married couple can petition for divorce if they can prove that there are exceptional circumstances of hardship suffered by either parties.
There are three grounds of dissolution of marriage, namely mutual consent, breakdown of marriage, and conversion to Islam. Mutual consent is when both parties agree to dissolve their marriage. Besides that, breakdown of marriage is divided into four grounds, which are adultery, behavior, desertion, and living part. For conversion to Islam, in order to dissolve a civil marriage when one spouse converted to Islam, all requirements in Section 48 Clause 10 must be fulfilled, which are the marriage has been registered or deemed to be registered, the marriage is monogamous, and both parties are domiciled at Malaysia at the time of their petition. The provision of Section 88 of LRA provides that children's conversion should depend on both parents and subject to the child's wishes when they obtain the age of majority, which is 18 years old. This means that a spouse who convert to Islam cannot use the religion, in the case of men especially, as a way to escape their marital obligations by unilaterally converting his children with the intention of getting custody over them easily. The next part is the effect of conversion to Islam on marital status. Basically, when one spouse in a civil marriage convert to Islam, the marriage will not be automatically dissolved unless either party makes a petition for divorce at the court. The minimum 2-year marriage requirement is not applicable to make petition for divorce. Generally, the converted party and the non-Muslim spouse will have to be present at the hearing, and at the end of the case, decree nasai will be granted by the court for 3 months. After the time passed, the non-Muslim spouse will be legally divorced.
Ahead, in the LRA 1976, it provides power to the court to order to either the spouse to pay for the maintenance depending on their ability to provide themselves. This means that provide for during and after the marriage. However, the statement from LRA 1976 is violates the Sharia law. It is because in the Sharia law, it is believed that the husband must pay for the maintenance for the ex-wife only during the iddah. Therefore, after the iddah, the husband is not responsible for paying the maintenance for the wife. And the LRA is said that the either spouse should pay the maintenance. However, in the Islam, the wife are not obligated to pay the maintenance for their ex-husband after the divorce. Solving the conflict between LRA 1976 and Sharia law is complicated because different principles involved. The Sharia have ruled in favor of non-convert wife in the past. Take a look into the Ramadan and Lichuman case. In the Lichuman case, this involved the same issue was presented before the civil court for consideration, and the outcome in the Lichuman case was remarked and criticized in the Tang Sung Moy and Tu Mew Kim case. In this case, the Supreme Court had looking to the Parliament intention while enacted Section 51 Clause 2, namely granting protection to the non-Muslim spouse and children against the Muslim convert. The court have jurisdiction to hear and determine the ancillary position despite divorce was denied under Section 51.
Alright, to continue back from the explanation about the maintenance of divorced wife, basically here the judge in the preceding case interpreted the LRA to apply only to non-Muslim marriage and ruled that the converted husband was subject to the LRA because he was not Muslim at the time of the marriage. Additionally, Malaysian Civil High Courts have authority to hear ancillary issues in non-Muslim marriage, such as alimony. Plus, according to the Section 51 of the LRA Act 1976 state that protects non-Muslim spouses, especially wives, from injustice. Therefore, even though the husband has converted to Islam, it cannot be used to rebut legal obligation for non-Muslim marriage. Furthermore, in LRA Act 1976 stated that entitles a non-Muslim wife to maintenance from her non-Muslim spouse after iddah, but in the Section 77 Clause 2 may require her to provide maintenance to her non-converted husband if he is unable to make a living. This contradicts Islamic law. Not just that, the rule is unjust to the wife because she is responsible for her husband's maintenance. Plus, it is unlikely that the wife would convert to Islam to avoid her responsibilities under the LRA Act 1976. Therefore, the clause has never been applied.
Next, for the child custody, if the children is boy and still in school at the age of 18 or girl who is still not yet married, the father is required to support them financially. Judge in the case of Tang Sun Moy versus Tu Mei Kim has made it clear that even though the father has converted to Islam, he is still compulsory to pay maintenance for his children.